The Negotiable Instruments Law. 5. Liabilities of parties. Section 60. Liability of maker. The maker of a negotiable instrument, by making it, engages that he will pay it according to its tenor, and admits the existence of the payee and his then capacity to endorse. Section 61. Liability of draw. The drawer by drawing the instrument admits the existence of the payee and his then capacity to endorse, and engages that, on due presentment, the instrument will be accepted or paid, or both, according to its tenor, and that if it be dishonored and the necessary proceedings on dishonor be duly taken, he will pay the amount thereof to the holder or to any subsequent endorser who may be compelled to pay it. But the drawer may insert in the instrument an express stipulation negativing or limiting his own liability to the holder. Section 62. Liability of acceptor. The acceptor, by accepting the instrument, engages that he will pay it according to the tenor of his acceptance and admits a. The existence of the drawer, the genuineness of his signature, and his capacity and authority to draw the instrument, and b. The existence of the payee and his then capacity to endorse. Section 63. When a person deemed endorser. A person placing his signature upon an instrument otherwise than as maker, drawer, or acceptor, is deemed to be endorser unless he clearly indicates by appropriate words his intention to be bound in some other capacity. Section 64. Liability of irregular endorser. Where a person, not otherwise a party to an instrument, places thereon his signature in blank before delivery, he is liable as endorser, in accordance with the following rules. A. If the instrument is payable to the order of a third person, he is liable to the payee and to all subsequent parties. B. If the instrument is payable to the order of the maker or drawer, or is payable to bearer, he is liable to all parties subsequent to the maker or drawer. C. If he signs for the accommodation of the payee, he is liable to all parties subsequent to the payee. Section 65. Warranty where negotiation by delivery and so forth. Every person negotiating an instrument by delivery or by a qualified endorsement warrants a. That the instrument is genuine and in all respects what it purports to be. B. That he has a good title to it. C. That all prior parties have capacity to contract. D. That he has no knowledge of any fact which would impair the validity of the instrument or render it valueless. But when the negotiation is by delivery only, the warranty extends in favor of no holder other than the immediate transferee. The provisions of subdivision C of this section do not apply to a person negotiating public or corporation securities other than bills and notes. Section 66. Liability of general endorser. Every endorser who endorses without qualification, warrants to all subsequent holders in due course a. The matters and things mentioned in subdivisions A, B, and C of the next preceding section, and b. That the instrument is, at the time of his endorsement, valid and subsisting. And, in addition, he engages that, on due presentment, it shall be accepted or paid, or both, as the case may be, according to its tenor, and that if it be dishonored and the necessary proceedings on dishonor be duly taken, he will pay the amount thereof to the holder, or to any subsequent endorser who may be compelled to pay it. Section 67. Liability of endorser where paper negotiable by delivery. Where a person places his endorsement on an instrument negotiable by delivery, he incurs all the liability of an endorser. Section 68. Order in which endorsers are liable. As respect one another, endorsers are liable prima facie in the order in which they endorse, but evidence is admissible to show that, as between or among themselves, they have agreed otherwise. Joint payees or joint endorsees who endorse are deemed to endorse jointly and severally. Section 69. Liability of an agent or broker. Where a broker or other agent negotiates an instrument without endorsement, he incurs all the liabilities prescribed by Section 65 of this Act, unless he discloses the name of his principal and the fact that he is acting only as agent.